Has he taken off?
All right, Ms. Fenton and Mr. Fry, I think you're here on an A file. We are about 45 minutes behind due to staff shortages. So I would ask that you log back on about 10:40. Thank you.
Thank you.
Okay, let me get Mr. Bradish's file. All right. Do we have anybody victim impact wise on Bradish? No. Okay.
No.
Okay, so this is in the matter of the people of the state of Michigan versus Jeremy Allen Bradish. Is it Bradish or Bradish, sir?
Bradish.
Thank you. File number 21-20314FH. I have Angela Borders appearing on behalf of Mr. Bradish. And I have Ashley Messer. Could I have your P number, please?
Yes, Your Honor, it's 76062.
All right, thank you. Appearing on behalf of the Attorney General's office. This is a date and time set for a delayed sentence. Plea in this case was taken back on November 9th of 2021. And this has been adjourned multiple times and finally set for today. Ms. Walsh is the probation officer on this. I do have a note that states a payment was made in March of 2024 for $4,000 in February of 2022 for $1,844.03. Ms. Messer, do we have a balance on the arrearage at this point?
We do, Your Honor. The balance is $1,739.35.
All right, so no, hold on. So the plea agreement was that if he pays $8,000 by February 7th of 25, the conviction would be reduced to a misdemeanor for disorderly. So now you may, Ms. Borders.
Thank you. I have been in contact with Ms. Brenner and Ms. Messer. I don't know if you're able to access this information, but it's my understanding that they show that he had made that final payment, but it just had not cleared the account on your end. Was able to see that. I had confirmed that with her week, late last week, early this week, I think, actually. She just said that it had not posted to the account, but that she could see that the payment was made.
Okay, do you have any notes, Ms. Messer? I can make a quick call to the case worker.
I do, Your Honor. I looked that up. I was going to bring that up to the court. There's been payments that have been applied to the balance after that payment was made, but for some reason, the payment that would pay off the balance is being held by a friend of the court, and it has not been applied yet. And I'm not sure what's going on with it, especially since there's been payments after that have been applied. But it was for $1,995. So then we're in the zero range. I just don't know what's going on. It says it's being held. I'm not quite sure why.
Okay, so how do we wish to proceed today, Ms. Borders and Ms. Messer?
Your Honor, I would think the opportunity for the defendant to go to the front of the court and figure out what's going on with that payment, why it's being held.
I can find that out in 2 seconds. Hold on. Hi, Mr. Vasquez. This is Judge Anslone, and I'm on the record on a case. And I was hoping you could explain a procedure to me. I'll give you the file number. It's 21-20314FH.
21-20314.
Yes, sir. Oh, no, that's my felony case. I'll give you the last name. I'm sorry. Jeremy Bradish. B-R-A-D-I-S-H. And
Jeremy, common spelling.
Jeremy Allen. Yeah, Jeremy's
Bradish.
common spelling. With an E, 2 E's.
The other party's Brandy.
Is the petitioner on this case Brandy? Yes.
Okay. I got it.
So, a payment of 1,900 was made and it's being held. Has it been processed or? So we think there's a 0 arrearage. But the AG's office said there was like a payment made and it's being held and they're not sure why.
Okay, yeah. Okay, you want me to give you the total balance on the case right now?
Sure.
Okay, 1739 and 35 cents. Let me check on the house. Was that 1,900 made in cash or how was that paid?
Did you pay that in cash, Mr. Bradish, or? how
Yes,
did you
I
pay
did.
it?
Yes, I did. $1,995 I paid in cash. I have the receipt.
Oh, no, that's all I needed, cash.
Okay, I'm showing it is pending and being held, large payments like that, and it was just made, it looks like on the 13th of February. So no, counting has to do that manually, and it takes a little bit longer for larger payments like that, so.
Okay, but it'll be applied to this case.
Let me see. It should be, I don't show it, being split up, but, until it's applied, I won't know that, but it is pending on this.
Okay, awesome, thank you,
No problem.
bye-bye. So yeah, it's being held because it was a large sum of cash, and so it goes to our accounting department and it will be applied.
Perfect. All right. So I think then my position would be the arrearage is 0 with that payment applied. So then I would like to proceed with the other part of the agreement and the entry of the conviction for the disorderly person.
Okay. All right, no objection to that, Ms. Borders?
No, that was the hopes.
All right, can I proceed to sentencing then?
Yes, Your Honor.
All right, so Mr. Bradish, have you had an opportunity to read and review the pre-sentence report?
No, I don't know.
We haven't
Okay,
pre-sentence report for this file. We did a long time ago regarding, but there was some confusion about that as
so
well.
Mr. Bradish, what I'm gonna do on this is fines and costs because it's been reduced to a misdemeanor. So anything that was recommended in that pre-sentence report is gone. So just to give you an update, because it's a misdemeanor at this point, there's gonna be state costs and like $50 and $75, I think. So what I'll be sentencing you to is a crime victim rights fee of $75 and a state cost of $50. So do you need more time to speak with your attorney about the sentence?
Well, I guess, when do I have to pay that? Is that all I gotta do is pay that $50 and $75?
You gotta pay the $50 and the $75 within 45 days.
I got no problem. I can do that. I can
So my
actually,
question to you was, do you need time to speak with your attorney?
no, I don't think so.
Okay, are you satisfied with your attorney and the advice that she has given you?
Yes.
Okay, Ms. Borders, I know you reviewed the report. Do you wish to explain or challenge the accuracy or relevancy of any of the information in the report?
No,
I show that he has 2 prior misdemeanors, no prior felonies, so you don't dispute that or the any constitutional defects in his prior offenses.
that's accurate.
All right, guidelines won't apply anymore. So is there anything, Ms. Messer, you would like to say on behalf of the Attorney General's office?
No, Your Honor. Thank you.
All right, Ms. Borders, anything on behalf of your client?
No, I'm just proud of him for actually paying. You know, we often say that they don't, and he worked hard to do that. And I appreciate the sentence, Your Honor.
Okay, Mr. Bradish, is there anything you'd like to say on your own behalf?
No, thank you. I appreciate the opportunity to pay this off and get it out from underneath me. Thank you.
You're welcome. So, Mr. Bradish, as your attorney referenced, we have quite a few people that fail to pay child support and end up charged with felonies as they should be, because you, woman or man, you have an obligation to support your children. Very few people make an effort to actually pay this off during the probation term or a delayed sentence. And you will be an example in the future of someone who worked really hard to do that. And I do reference people like you when I sentence other individuals under this. So thank you so much for, you know, doing that and putting in the work to do it. So it's a sentence of the court that you will pay $75 in crime victim rights fee, $50 state cost. I'll give you 45 days to pay that. Are you in Michigan?
Yes, I am.
All right, so you would just pay that on the third floor of the courthouse at the clerk's office, okay?
Okay.
All right, Ms.
Okay,
Messer.
Now
ahead.
I have a, will I be getting something sent to me, or if I just went to the third floor, they would know I could pay it? Like if I came in here, I
Yes,
could pay it
just give them
today?
your name and they'll look it up and they will, yep.
Okay, thank you.
Thank you. Ms. Messer, thank you. And Ms. Borders, thank you
Judge.
for your patience this morning. Ms. Adams?
I'm sorry, will we be getting an amended information on that?
Ms. Messer, you'll do the amended information, send it over.
Absolutely.
Thank you.
All right, excellent. All right,
Thanks.
thank you, Ms. Borders and Mr. Bradish and Ms. Messer. You have a good day.
You too,
You
Yara.
too.
Thank you.
Have a good weekend.
Thank you. Okay, so I got Michael Dagger-Margosian, I got Brandon Underwood, I got Sam. I have one person in my waiting room, Shelton Hicks, that's Rhonda. And Mr. Bradish, I'm gonna help you on your way. Oh, he found it. I'm gonna call the jail and we have,
The other three are here.
to see if we've got picked up for district court. I guess I do know where his mom is. All right, so they're all here.
Yes, sir.
All right, so, Mr. Edwards, Mr. Madrid, and Mr. Mauer are here.
Mauer should be in the jail.
No, they're all in
No,
person.
they're in person. They're in lockup.
Oh, they're here.
Yeah.
Oh, okay. I didn't know what doctor.
So you're ready then. All right. So who do you have?
Here I have Mr. Rowley here. Mr. Kapnick is in the hallway, and then Mr. Edwards is ready, but he's in
Lockup.
lockup here.
Okay, so Mr. Rowley. So many jokes. Like, just like, no, I don't know. I didn't put one up. So everybody was being super helpful.
Kapnick or Rowley? I'm sorry.
We're gonna do Rowley first.
Okay.
Okay, so this is in the matter of people of the state of Michigan versus Joshua Dexter Rowley. We have two files, 24-21957 FH, 24-21911 FH. Miss Adams, I do have an email. Mr. Dagger-Margosian represents Mr. Rowley. Mr. Rowley, I have adjourned the sentencing 3 times to get fingerprints, and also because of the bench warrants, he has still not gotten his fingerprints done.
Correct, Your Honor. The issue is he's trying to get his state ID, and he can't get his fingerprints without that. There was an issue at the house where his paperwork was thrown out, and in any event, he's trying to get the ID, but he can't get it, and therefore he can't have the fingerprints done. So, and Your Honor ordered him to be here in person today. That's where he came from Kalamazoo to be here.
Are you currently employed?
I actually just got a job, yes, ma'am.
Well, I can get his fingerprints if I can put him in custody.
Well, I'd like to avoid that, but obviously, I mean, he did have his finger, I know the court is frustrated with this process, obviously. He did have his fingerprints originally when he was arrested.
I think they only did them on one file.
Yeah, I think that's right. And I don't think it's as easy as he can just go down to the station because he has to have this ID. So he's just like in the circle right now.
No, I've actually tried to go down there with the paper stating that I got in for my ID, and I had a digital picture of my old ID, and they wouldn't take that either. So,
But you've been waiting in the mail for it to be mailed to you for like.
yes, I was. And then the gentleman, it was my niece's address that I was using, and her boyfriend threw my mail out. She told me, so it got there. He just threw it away.
Is there anybody here for the victim advocate today? So, Mr. Dagger Margosian, this is a so have you gone back to get another copy?
Yes,
When did you do that?
I ordered, it was online. It was late last week sometime, I'm not really sure. It was,
And how long did they say it would take?
I think it was Thursday. 10, I think it was 14 business days, I want to say. I don't know what the max was, but I know it says usually within 14 days.
Ms. Adams, could I get a sentencing date for the week of March 17th? And I'll need notices, please.
We could do Friday, March 21st at 8:15.
Are you available?
Yeah, that's okay.
All right, so Mr. Rowley, I'm going to set this for March 21st, 8:15. As soon as you get that, go get your fingerprints done. I don't care if I have to take you into custody for half a day and get the jail to fingerprint you, I will do that. I mean, I'm not gonna leave you in there, but I know if I take you into custody, I'll get you some fingerprints.
I was gonna say, I don't have to work today, ma'am. If you want to stick me in there for a couple hours,
That should not be, I
understand.
Yeah.
So what I'm saying, as soon as you get your license in the mail, this gives you a month.
Yes.
As soon as you get your license in the mail, go get fingerprints done. If they won't do them, come back to Mr. Dagger Margosian and we'll talk to somebody at the jail and see if we can get them done for you. Okay, so keep Mr. Dagger Margosian posted, and then Miss Adams, if I can get a notice of hearing from Mr. Rowley.
And then Your Honor, I mean, I guess there's no way that we can just make the condition of probation to get the fingerprints so that he can be separated.
I'm not allowed to do that.
I got you. And then can he, because we know because there is a sentencing agreement on this, can he show up on Zoom? Is that okay?
Yeah.
Okay.
As long as I got prints.
Yeah, right.
If I don't get prints, it's got to come in person.
Understood.
Okay, sir, have a seat right behind you and we will get you a notice of hearing.
Thank you.
All right, so, who's in the hall?
Kapnick.
Miss, I don't have Miss Underwood. I probably lost her at district court. Do we have anybody making a statement on Kapnick? Mr. Dagger Margosian, we emailed to you an updated statement this morning. You received that?
I have, yes.
Are you on this one?
It's weird.
Oh, there's, okay. Could you stand at the podium, please? I'm sorry, district court, you sit down, circuit court, you sit up, I don't know.
And Judge, no victim appeared. I just would like to make a statement, but that's why I'm on Zoom, just because I knew she wouldn't be there.
And if we could, remember, we use initials.
Yes, yeah.
All right, good luck. So this is in the matter of the people of the state of Michigan versus Jeffrey Lee Kapnick II. We have file number 24-21720FH. I have Michael Dagger-Margosian appearing on behalf of Mr. Kapnick, who is present in the courtroom. I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing. Mr. Dagger-Margosian, just for the record, you did receive a copy of the PSI along with the updated victim impact statement.
Correct.
All right, and Mr. Kapnick, have you had an opportunity to read and review the pre-sentence report?
Yes, no.
Okay, you guys can move that if you want. And you've had an opportunity to discuss that with Mr. Dagger-Margosian?
Yes, Your Honor.
All right, are you picking that up, Ms. Schwartz?
Yes.
Okay, Mr. Dagger-Margosian, or I'm sorry, are you satisfied with Mr. Dagger-Margosian as your attorney and the advice that he's given you?
Yes, Your Honor.
All right, Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Nothing in the body of the report, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show no prior record at all, including no juvenile.
Yeah, I have
Okay.
nothing to add.
The probation department has calculated the minimum sentencing guidelines on both counts to be 0 to 17 months. Do you, is it 0 to 17 or, yeah. Do you agree with that computation of guidelines?
Your Honor, I think I would like to challenge OV 11. I didn't submit anything, but I think we could take care of it today if.
Hold on, let me get it.
Yep.
So I'm going to my book. 4, 6. OV 11 is criminal sexual penetration. It's scored at, let me see here. It's scored at 25 points for one criminal sexual penetration occurred. And okay, and Miss McClure, I'll let you get there.
Yep, I'm here.
And I do see that there was a transcript, so we can access that record as well. So hold on one second. Let me go back through the narrative of offense. All right, so there was an interview where the victim indicated that her father had forced her to perform oral sex on him and had penetrated her vagina with his finger. So I'm going to presume that was the score for that. So
well,
go ahead.
So for OV 11, Your Honor, there needs to be a penetration additional to the sentencing offense, and it must arise out of the same course of conduct. In this matter, the date range of offenses are fairly unclear. I mean, the information lists it as 12/16/2020 through 2/15/2023. At the exam, the victim stated that there were 3 incidents, but that they occurred on separate dates, and that in my reading of the transcript, there was not a showing of an additional penetration additional to the sentencing offense on each of these 3 convictions. So for that reason, I think it's improperly scored. It should be 0.
All right, so OV 11 scores all sexual penetrations of the victim by the offender arising out of the sentencing offense. Criminal sexual penetrations of the victim of the sentencing offense, which did not occur during that offense, may be scored in OV 12 or OV 13 where appropriate, pursuant to the instructions for those variables. Points are not to be scored for the one penetration that forms the basis of a first degree or third degree criminal sexual conduct sentencing offense. Talks about rubbing of the vaginal area. Okay, so where the trial court scored OV 11 on the theory that there were additional sexual penetrations of the victim by the defendant arising out of the sentencing offense, but the record does not establish when these non-charged sexual penetrations occurred. There is no evidence in the record supporting a finding that there were additional sexual penetrations arising out of the sentencing offense, and thus OB 11 was erroneously scored. People v. Thompson, 474, Mish 861, 2005. He pled to 2 counts of criminal sexual conduct, 4th degree. I'm sorry, so Ms. McClure, are you able to respond at this time?
Yes, I do believe the record substantially supports scoring OV 11. I would point to the exam transcript where the victim did testify to an additional oral penetration that was not a part of the original charges in this case, but it was, and that was only simply because we weren't exactly sure where that had happened, but it was around the same date as what was charged. And she did testify to that and testified pretty substantially as to that oral penetration. So in addition to what he was charged with, and then this obviously being a reduction, I think you could count any of those penetrations under the law or under the controlling law for OV 11. But in addition, we had the one that she did testify to that was around the same time as these charged offenses.
Now, my pre-sentence report, Ms. McClure, states that the victim indicated that the assaults were always similar and always involved both vaginal penetration with his fingers and oral sex. She stated that this occurred more than 5 times and that the assaults would happen once or twice a day. Was that testimony taken from the preliminary exam transcript or?
It was, and I believe in addition to that statement, she also detailed at least 3 during the testimony.
Mr. Decker-Marcos in response.
Yeah, the statement of 1 to 2 times per day was not part of the exam transcript, at least when I read it this morning. I may have, but I think that was not part of the transcript. I do agree with Ms. McClure of the, at the exam, the testimony of the 3 different incidents. But again, those were not part of the same concept. Those were all separate incidents. So that's my argument.
And I didn't review the transcript, Judge, but I did review my notes from the exam where at least my recollection was that she testified to 3 separate penetrative incidents. My note was, there would be another acts notice given the number of times she testified to. That's what I was relying on to say, yes, she did testify to, happened multiple times over the course of, or throughout this time period.
And I agree with that, just so to be clear.
Anything else? All right, so the felony information in this file indicates that during the time period of December 16th of 2020 through February 15th of 2023, that the defendant did what he's charged with, 1st degree CSE, which is a life offense, and obviously it was pled down to the 2 offenses we're here for today, which are 4th degree. We do have preliminary exam transcript testimony from the victim that there were more than 3 at least digital or oral penetrations. Therefore, I believe that under People v. Thompson 474 Mish 861, there was evidence on the record to support a finding that there were additional sexual penetrations arising out of the sentencing offenses. I am going to leave OB 11 scored that way. So any other objections?
No, thank you.
Okay. So I will leave the guidelines scored at 0 to 17 on both counts. All right, did you have any objections to the guidelines, Ms. McClure?
No, thank you.
All right. So, before the court passes sentence, is there anything, Ms. McClure, you'd like to say on behalf of the people? I have read the victim impact statements.
Okay. So just to elaborate on that, and I know I've made this spiel kind of in front of you before, Judge, in these types of cases, and I know looking at what the charge defenses were and kind of the facts that were alleged here, and then looking at what the plea bargain charge was. I always like to mention at sentencing, you know, there's a lot of reasons why these plea offers are taken, and I would just like the court to consider that I did consult with the victim and her mother in bargaining this plea, but in addition, just I would like the court to consider her mental state at the time as we were approaching trial, how this affected her. And I think you can see through the victim impact statement that it did greatly affect her and has over the years. I think it would have done more harm than good to have her testify at trial. She did testify at the preliminary exam, but again, that was a couple of years ago. So by the time we were approaching trial, I think it would have been somewhat of a setback. And I considered that in making this plea offer. I know the recommendation here is that he serve 1 year in the Lenawee County Jail with 8 days for credit. I just think given where we were at when this plea was taken and prior to the trial, I would ask the court to defer that jail sentence. I think that would be more appropriate given why we had to make this plea agreement. I know that's uncommon for me to ask, but I would just like the court to take that into consideration. I do think it's a fair recommendation, and typically in these cases it would be fair, but in this case I would just ask that maybe that be deferred and all other sentences as recommended would be imposed.
Well, I'm sure that just took the wind right out of your sails. Mr. Tuggermer goes in to ask for no upfront jail.
Your Honor, I did speak in length with Ms. McClure on this matter. I agree with what she stated. I'm not going to elaborate the point, but I will say that, you know, we were prepared to move forward with trial. In speaking with Mr. Kapnick and in conducting the exam, as diplomatic as I can be, I was skeptical of the case. And so Mr. Kapnick didn't want to put his daughter through this again. And so for all those reasons, that's how we've landed with this agreement. So I guess I would just ask the court to follow the proposal by Ms. McClure of the suspended for however we want to label it, incarceration. This court has heard me make objections to provisions 4 and 5. I know where the court stands on that, so I'll just note that for the record. But other than that, Mr. Kapnick is, as the court saw in the PSI, there's no criminal history of any kind. He is working. He wants to move forward from this. So I'm asking the court to follow that the people's recommendation.
All right. Anything you'd like to say in your own behalf? I'm sorry, Ms. McClure, go ahead.
Okay, just a brief response. Just that I don't want the plea offer or the sentence here to reflect that I guess the state does not believe the victim in this case, and that's not what my position was at all. And I do hope that the defendant does take accountability for his actions and that at some point issues an apology to the victim and her mother in this case. Thank you.
Okay. Anything you want to say on your own behalf, Mr. Kapnick?
Not quickly, no.
All right, it is determining the appropriate sentence in this case. The court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. It is a sentence of the court that you will be placed on probation for a period of 5 years with the Michigan Department of Corrections. You are going to pay $750 in court costs, $130 crime victim rights fee, $136 in state costs. That's two combined there, $60 DNA fee, $30 per month supervision fee, and $60 per month if we have to put a tether on you. You are to remain active on the Michigan Sex Offender Registry for life. School safety zone restrictions will be ordered. You are to have no contact with the victim in this matter, directly or indirectly. You are to have no contact with children aged 17 years or younger. You must enter and complete sex offender treatment. I'm going to defer the 1 year in jail that I was going to order based on the recommendation of the prosecutor's office. And I will give you credit for 8 days, but understand if you violate probation, not only could you be looking at a year in jail, you could potentially be looking at up to 17 months in prison. Do you understand?
Yes, Your Honor.
Your attorney, and you should be grateful to your attorney. He worked out a very good deal for you. During the terms of probation, not to violate any criminal law of any unit of government. As I said, no contact with anyone under the age of 17, complete treatment. Now, your attorney objected, as he always timely does on these cases, to the restrictions that you can't reside, work, or loiter within a school safety zone, or defined as 1,000 feet of school property, developmental kindergarten through 12th grade. Unless you need an exemption, you're not to be within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, or other places primarily used by individuals age 17 or under. I am going to order those terms, but I do note that your attorney did make that objection. As I said, you're required to register. Make sure you're in compliance with that. Failure to do so could result in another felony. You are not to have any access to the internet using any device prior to completing and signing the MDOC Internet Use Agreement. You can't leave the state without the consent of this court, which you would get through your probation officer. You're not to use or possess alcohol, use any illegal controlled substances, and you are to test as required by the probation department. You must report monthly or as often as they require. And if you have police contact, move, or lose a job, you need to let them know right away. Failure to do so could result in a violation of probation. They also have the right to search your person, your property, your vehicle, your residence, your computer without the need of a warrant if they have reasonable cause to believe that you have items which violate the conditions of your probation. So, Mr. Jones, when do you want him to report?
Next Tuesday's fine.
What time?
Whatever works best for him.
Okay, so you need to report between 8 and 12 next Tuesday morning, all right? Now, my bailiff's gonna hand down to you the notice of right to appellate review. You're gonna initial and date the top copy for our records to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. McClure and Mr. Degemer-Gozine, thank you.
Thank you.
There's no jail, right?
No, I deferred it.
Okay. No days deferred, just zero. You didn't say any days deferred, just zero.
I gave him 1 year jail deferred with
Oh,
8
okay.
days credit.
Thanks.
I'm keeping really good notes too.
Okay. I missed that part.
All right, is there anybody else in the courtroom here for sentencing or waiting for an inmate?
Sure, people be Edwards room.
Okay, is he here?
He's in jail.
He's in the back.
Oh, can we have Mr. Edwards?
Person.
Record should reflect I received back signed copy of the notice of right to appellate review. I mean. Right. We just have, let me see. Moore's in custody. Madrid is in custody. Is it Barrage in jail?
No, she's not on the jail sheet.
You know where Miss Barrage is?
I don't, she had a district court case today, so I'm gonna go check there after.
Mr. Moore, what's our status on Colleen Barrage? She's a recovery court, so.
Oh, that's a good question. Give me a second, please.
I just don't know if she's absconded from recovery court or. We'll pass that one. And I can do that after my hearing with my civil family law docket. All right, so, can they bring Alphonse and Mauer down together or no?
85-28, bring Mauer down to those.
Mr. Brooks, sorry for kicking you out of the courtroom, but I realized that wasn't the first time that's ever happened to you.
Your Honor, you always say it with a smile on your face, which eases.
The cut, yeah.
I was told to come back at 20 minutes to 10, or 11, when he's.
We're about 15 minutes away, so,
Your Honor,
yes, sir.
she should be in jail at the VOP, so she was continued in recovery court, given 45 days jail, and so she'll be assessed to be sent to treatment, so she should be over at the jail.
Can we call her? She wasn't on the sheet, so maybe they just.
Who's this again? Mr. Edwards?
Yes.
Mr. Edwards, if you can just stand. Hi, this is Judge. What'd you say your last name is?
Cavatos.
Are you related to Karina?
Well, that depends which one.
Okay, well, the one that's my friend. But anyway, so do you have Colleen Bar at the jail?
I believe so. Last I checked, we did.
Okay, thank you.
Yeah.
Bye. Yeah, that's it. Bye-bye. Okay, so this is in the matter of the people of the state of Michigan versus Alphonse Eugene Edwards, file number 24-21995FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Edwards. Mr. Dagger-Margosian, I received an updated victim impact statement. Did you?
I did, yes.
Yep, and you received that as well?
Yes.
Do we have anyone here to speak today? No? All right, it's enough, and I'm nodding to the victim in this matter. Is it enough that I read your statement?
I wanted you to.
Okay, do you want me to read it on the record?
No.
Okay, thank you. All right, so, Mr. Daggermark, or Mr. Edwards, have you had a chance to read and review the pre-sentence report?
Yes.
Can you step forward and speak louder for me?
Yes.
Okay, thank you. Have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes.
Are you satisfied with your attorney and the advice that he has given you?
Yes.
Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. Dagger-Margosian, does the pre-sentence report disclose any prior convictions in which there exists any noticeable constitutional defect?
Not to my knowledge at this
All
time.
right. The probation department has calculated the minimum sentencing guidelines to be 19 to 38 months. Do you agree with that calculation of guidelines?
I don't have any challenges at this time.
All right. Do you have any challenges, Mr. Sneed?
No, thank you.
All right. Before the court passes sentence, Mr. Sneed, I have reviewed the victim impact statement. It was very heartfelt. It was very thought out. Is there anything you'd like to say on behalf of the people?
No, thank you.
All right, Mr. Dagger-Margosian, is there anything you'd like to say on behalf of your client?
Your Honor, the victim impact statement obviously shows that there is a emotional, heartfelt relationship between these two. Unfortunately, there was an incident that obviously has led us to this point. I know Mr. Edwards is apologetic, didn't want it to come to this point. He did take ownership of the situation. He obviously has entered a plea and is accepting responsibility. I hope and know that after the sentence, he will be a better person, and he's going to use it as an opportunity to move forward and correct some patterns within himself. I don't know if he wants to address the court, but I really, the sentencing agreement is what it is. And so I would ask the court to follow that. The only, I guess, additional item that I'd ask the court to consider is the amount of time that he has been in jail. It reflects in the PSI that it's been 228 days. The parole, Mr. Edwards being on parole at the time of the offense, may preclude him from receiving that, but if there is any possibility of him receiving that, then I would ask the court to consider that or take it into account some other way, even though there's a sentencing agreement. So I just wanted that to be put on record.
Mr. Moore, he was on parole.
Yes, he's on parole, Your Honor. So he wouldn't get credit for any time served.
For his parole violation. Okay.
Correct.
Anything else, Mr. Dagmar?
No, thank you.
All right, Mr. Edwards, is there anything you'd like to say on behalf of yourself?
Yeah, I would like to apologize to the victim. I don't know what led up to the situation happening, but it happened. I think the worst thing you can do is violate the trust of somebody that loves you, somebody who feels safe in your presence. This violated all that. And I know no matter what I do, no matter what's being said, she would always remember those moments. I can fight back. I can do whatever I can for the rest of my life and it'll still be there. I'm sorry. And there's nothing else I can say.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. So as I reviewed the pre-sentence report and the updated letter, you loved her, she loved you, and you beat her. I mean, the pictures are horrific. And I was a defense attorney for many years before I became a judge. And this is one of the worst ones I've seen. And ma'am, I understand what you're saying in this letter, but one thing my mama taught me is that just because you love someone doesn't mean they're good for you. Because we can love a lot of people who aren't good for us. So you need to get counseling. You need to get counseling. You can't do this. You can't live your life like this. And you have, let me see here. You have piddly stuff when you were younger, but assaultive behavior when you were younger, RNOs. You have a 2000 offense that was assault with intent to murder. Obviously 2024, this offense, obviously there's something in that's not maybe what is you, but something causes you to do these things and you need to get the help for that. So you don't do this ever again. And I think you're sincere that you don't know what comes over you, but you got to figure that out, right? Whether it's taking medications, going to counseling, whatever it is. And I hope you do. Sentence to the court that there was an agreement, the Cobb's agreement to sentencing for 36 to 60 months. So it's sent to the court that you will serve 36 months to 60 months with the Michigan Department of Corrections. He was on parole. Any credit he has will go to that parole violation. So it may start right away on this one. I don't know how DOC will do it. During that term of parole and incarceration, you're not to have any contact, verbal, written, electronic, or physical contact with the victim CB in this matter directly or through another person. And you can't be within 500 feet of their residence, school, or place of employment. Ma'am, that means you can't contact him either. You understand? Because he could get in trouble if you contact him. You must obey our court orders. When you're on parole, obviously there'll be terms of notice of PPOs to the parole officer, but there's a crime victim assessment fee in the amount of $130 and $68 in state costs. Mr. Edwards, get the help you need so this doesn't ever happen again. All right, now you do have the right to appeal the sentence. My bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date one copy for our records to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Moore, can I order that he participate? Like, will that help him to be able to participate if I order programming for him? Or no?
Yeah, you can order it. I believe he's going to, because it's assault offense, gonna have to participate in anger management, but I would order, you can order it for parole.
Well, if he's gonna already be able to, I just want to make sure he has that opportunity. All right, you're all set. Thank you. I received back a signed copy of the notice of right to appellate review. All right, Mr. Mauer.
Can I run downstairs and I'm back?
Who's the defense attorney for him?
Sam.
Sam, is that? Yeah, now, Mr. Degemer goes in, she's in jail. I'm not gonna be able to see her till about 11, so you gonna be you. Okay, thank you. Becky, if you can let the jail know, we'll see Colleen Bar around 11-ish. All right, so, all right. This is in, if you can just talk in the hallway, please, thank you. This is in the matter of the people of the state of Michigan versus Jonathan Remington Mauer, file number 24-22005FH, 24-22006FH, 24-22007FH. I have Salvatore Malaro appearing on behalf of Mr. Mauer, and I have Isaac Sneed appearing on behalf of the people. Ms. Holly is present from the Michigan Department of Corrections. Mr. Malaro, you received a copy of the pre-sentence?
Did, Your Honor.
All right, Mr. Mauer, have you had an opportunity? Pull that microphone closer to you, please. All right, Mr. Mauer, you've had an opportunity to read and review the pre-sentence report?
I've looked at most of it, yes, ma'am.
Has Mr. Malaro explained it all to you?
He's explained what I needed him to, yes.
Okay, is there anything else that you wanted to review with Mr. Malaro? Because you have the time if you want to. No?
No, I don't. I'm just ready to get this over with, whatever it is. I've been in this county for 18 months.
Okay.
I'm just ready to do whatever.
Okay, are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yeah.
All right, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Mr. Steen?
No, thank you.
All right, Mr. Malaro, do you wish to, or does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge, Judge.
All right. So we start at the top. Count 1, file number 24-22005FH. Probation Department's calculated minimum sentencing guidelines to be 14 to 29 months. Count 2, on the felonious assault, guidelines were calculated 12 to 24 months. Count 3, assault with a dangerous weapon, 12 to 24 months. On count 4, police officer R&O, 5 to 23 months. Count 5, R&O, 5 to 23 months. Moving on to file number 24-22006FH. Count 1, felonious assault, 12 to 24 months. On file number 24-22007. Count 1, carrying concealed weapon, 10 to 23 months. Count 2, carrying with unlawful intent, to 10 to 23 months. And count 3, larceny in a building, 5 to 23 months. Do you agree with the calculation of guidelines?
We do, Judge.
All right. Before the court passes sentence, Mr. Sneed, we don't have anybody wishing to speak today. But is there anything you wish to say on behalf of the people?
Not this time. Thank you.
All right, in this case, your client did plead no contest to these offenses, and that was, obviously that report reflects that. Mr. Malaro, is there anything you wish to say on behalf of your client?
I do, Judge. I've known Mr. Mauer now for several years, represented him on numerous
matters. It's clear that Jonathan has mental health issues, and I think it's also clear that sometimes it gets exacerbated by drug use, which I think is pretty well known by this court. That being said, Mr. Mauer, when these matters occurred, and shortly thereafter was deemed incompetent but restorable, and it took a considerable amount of time for him to be restored to competency. When he's on his game, Jonathan's a pleasant enough individual, and I think the report correctly reflects that he has bipolar disorder, and I think sometimes the problem with that is people with bipolar disorder don't maintain proper relationship with the medical provider so that these things don't happen. And it's tragic, and Jonathan feels bad when he's lucid. And so I know that there's a recommendation, Judge, on the first charge of 29 months, which is at the top end. He's been in custody now for 18 months. I would ask the court to consider perhaps coming off the maximums on these. There's been no sentence agreement in these cases. And if the court were to fashion a sentence within the middle or even lower end of these guidelines, I think Mr. Mauer would either be eligible for parole or could get put on probation sooner than later. And so that would be our request, Judge. I think he's ready to be in the community with proper medical supervision. And so that's our request.
So I'm going to pause real quick. My pre-sentence report, the way the report printed off on page 4 for the sentence on the carrying concealed at the bottom, I don't have the recommendation. I know the guidelines on that one were, and I don't know if you have that, on the body of the report where it goes to what recommendation is on each one of those. The carrying concealed were 10 to 23 months, but my page 4 right at the bottom has 24-22007 FH, count 1, weapons carrying concealed. And when I go to page 5, it goes to count 2. Were you recommending 1 year, 11 months to 5 years for both of those counts? I just wanted to make sure.
So the guidelines the same?
Yes, they were. I just wanted to make sure those were.
Yes.
Okay, got it. So it is 12. It will be, okay, the recommendation was.
I think it's 10 to 23, Judge. You go to.
Yeah, they were. I just wanted to make sure there wasn't a recommendation that got cut off, so never mind.
Yes.
Mr. Sneed, is there any response to?
Yes, Your Honor. The people are requesting the court to adopt the recommendation of 29 months to 5 years. In light of the seriousness of these crimes involving weapons, involving the general public, and resisting police, we think that it's more than proportionate to the crimes that are that took place in this case. Much of the credit was built up, I believe, due to forensic evaluations taking place. So, Your Honor, we'd ask the court to adopt the recommendation.
Anything else, Mr. Malone?
No, Judge.
All right, so Mr. Mauer, is there anything you want to say on your own behalf?
Just that I apologize to the court and the community for, being off the handle like that. I just wasn't on my medication. And I get like that sometimes, I shouldn't. But when people attack me and, stuff like that, it kind of makes me do things back. And I don't think it's fair that they aren't punished too.
Okay.
I mean, I'm not putting blame on anybody, but at the same time, I should be able to protect myself accordingly. And I shouldn't take it so far sometimes. And I do apologize for that.
Okay. So, Mr. Mauer, I appreciate that you recognize your medications are important. You do have a long history of assaultive offenses, and I'm going to guess that probably flows with that. So in determining the appropriate sentence in these cases, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and protection of society. Mr. Mauer, again, I appreciate your statements, but we're really lucky you or somebody else didn't die that day, you know, when these offenses occurred. And I'm glad that it wasn't you either, you know, but so on file number 24-22005 FH, count 1, carrying a concealed weapon. It's a sentence of the court that you will serve 14 to 29 months with the Michigan Department of Corrections. I will give you credit for 548 days already served. On count 2 and count 3, which were both assault with a dangerous weapon charges, you will serve 12 to 24 months with credit for 548. That one, he's already got credit for time served. Can I just give him credit for time served?
And go, okay, police officer Arno.
No, I'm on the
Oh, police officer.
24-22005 FH. It's a 2-year, well, it's a 4-year or 2-year, and you're recommending 12 to 24 months. Can I just give him credit for time served because he has 500?
Isn't that 4 years, police assault?
Oh, you're right. Okay. So I'll give you, it's a sentence of the court that you will serve 24 months to 48 months with the Michigan Department of Corrections. We'll give you credit for the 548 days already served. On count 4 and count 5, which are the police officer resisting and obstructing. Those are the 2 years, right? Not the 4 years.
Arno is.
Correct.
The old 5 FH cases, Judge, yeah.
Yeah, and the police officer, Arno, the recommendation is 1 year, 11 months to 4 years, but they're only 2 years, right?
Yes, they are 2 years. Yes, they are 2 years.
So on those 2 counts, count 4 and count 5, I'm just gonna give them credit for time served. Cause it's a 2-year, right?
Yes.
And Your Honor.
It's a 2-year.
Understood, yes. Could I just interject for 1 second? On count 1, the recommendation was for 29 months to 5 years. And I didn't catch what the sentence was for count 1.
For count 1, 29 months. It was 2 years, 5 months to 5 years.
Okay.
Yeah.
I think you're saying the guidelines. I think she said.
Because there's so many. So yeah, count 1 was 2 years, 5 months to 5 years with 548 days credit.
Okay.
And then on the 2 felonious assaults, 2 years, 24 to 48 months with 548 days credit. But then on count 4 and count 5, it also said a 4-year max, but it's only a 2-year max. So I'm just going to give them credit for time served on those.
Yeah,
then we're going to move on to file number 24-22006 FH. On count 1, felonious assault, sentence of the court, he'll serve 2 years to 4 years with the Michigan Department of Corrections with 545 days credit. On file number 24-22007 FH, count 1, carrying concealed, and count 2, carrying a weapon with unlawful intent. Sentence the court, he'll serve 1 year, 11 months to 5 years with the Michigan Department of Corrections. Credit for 532 days already served. And then on count 3, larceny in a building, sentence court that he will serve 1 year, 11 months to 4 years with the Michigan Department of Corrections with credit for 532 days already served. Does that cover all of them? I think it does.
Yeah.
On each file, there is a crime victim assessment fee in the amount of $130. And then for each count, there is a state cost of $68. Correct, Ms. Holly?
I'm sorry, just
130 on each file, but 68 on each count.
Yes, so the The 22005 is a total of 340 state,
Prison for 11 months.
and the other 168, middle one, and then the 22007 is 200.
Mr. Mauer, you gotta listen to this, hold on.
201.
For 340, then 68, then 204 for state costs.
204.
Okay, now, Mr. Mauer, you have a right to appeal this sentence. My bailiff's gonna bring down to, for every file, a notice of right to appellate review. He's just gonna have you initial and date the top copy, just your initialing and dating to acknowledge you received your appellate paperwork. The appellate paperwork will go with you. You can fill it out today if you want to appeal the sentence, or you can fill it out and send it to us within 42 days.
Judge, are these all to run concurrent?
And they all run concurrent.
Thank you.
How long do I have to do?
So you got 18 credit. 0.9 months, so you got 11 more months.
And you did credit for time served on the one that was 2 year.
And then the
Yeah.
years are- years.
Yeah, sorry, I messed that one up.
That's okay, there were a lot of them. Okay, so. So Miss Underwood, Mr. Hartung, Mr. Brandt, I am going to have to stop my criminal proceedings for a minute. Mr. Iddings, it shouldn't take long to do the review, or will it?
To find not take long. I mean, we have the review, we can try to expedite it as much as possible. I'm not sure how much other testimony is gonna be required, but we could probably accomplish it in 20 minutes.
Okay. All right, I think the rest of mine would be faster than that, so hold on, bear with me. You were right, Mr. Iddings, absolutely right about me. Do you have another hearing coming up?
I don't, I'm fine waiting. And I'm
Okay.
messaging my client, so she knows what's happening as well.
Okay.
I don't know if
I
you want to bring
apologize.
everybody in and
It's-
let them know what's happening.
Yeah, I'm gonna send a message to everybody in the waiting room that we will be with them shortly, and then I'm gonna do my 2 really short criminal matters now.
I'm sure Mr. Hartung will be as quick as he can.
You'll say very little in this one.
Thank you.
Thank you, Mr. Smith. All right, so Miss Underwood, your client is Shelton, right?
Shelton Hicks, yeah.
I got him. You ready? I don't know who the. Mr. Hill, I'll be with you just in a minute. Shelton Hicks. All right. Good morning, Mr. Hicks. How are you?
Good morning.
All right, so this is in the matter, the people of the state of Michigan versus Shelton Hicks. And this is file number 24-22050FH. I have Rhonda Underwood appearing on behalf of Mr. Hicks. And this is Mr. Moore's file. So Miss Underwood, on this file, you would have received an email this morning about updated guidelines.
I have not.
But let me explain what happened. So we have a new system through the Michigan Department of Corrections, and it would not allow Mr. Moore to generate guidelines on that count 1 attempted financial transaction device. Because I have to have guidelines to be able to sentence, I generated them and scored them 0 to 6 months. And I personally did those guidelines and they were very low.
Right. I understand
why the 6 month with Mr. Hicks's prior record is probably how we got up there, Your Honor. I understand that.
Yeah, so I had scored PRV 1 at 25, PRV 2 at 20. It was his prior record. PRV 5 was 5, 7 was 10, and his OVs were 1. So, yeah.
I think that is appropriate, Your Honor.
Okay, I just want to make sure you see that, Mr. Moore, you received it as well.
Yes.
Okay, so, Ms. Underwood, you've had ample time to speak with Mr. Hicks, or do you need to speak with him?
Mr. Hicks and I spoke yesterday.
All right, so Mr. Hicks, have you had a chance to read and review the pre-sentence report with your attorney, Ms. Underwood?
Yes, yes.
Good. Have you had an opportunity to discuss it with her?
Yes.
Are you satisfied with her as your attorney and the advice that she has given you?
Yes.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
I do not.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not.
All right. I calculated the guidelines on count 1 to be 0 to 6 months. Mr. Moore calculated the guidelines on count 2 to be 0 to 11 months. Both of those are attempted under the age grid. Do you have any objection to those guidelines?
No.
All right. There is a Killebrew agreement that was struck between the prosecutor's office, in this case because of the nature, to no upfront jail. So, Ms. Underwood, is there anything you'd like to say on behalf of your client before the court passes?
There is a lot I would like to say on Mr. Hicks' behalf, Your Honor, because as we stand here today, and I say this without equivocation, Mr. Hicks has undergone the biggest change, I think, of anyone I've ever seen since I've been standing here, Your Honor. Mr. Hicks was incarcerated. Mr. Hicks was declared incompetent. Mr. Hicks was very incompetent, Your Honor. I cannot tell you the time I spent with Mr. Hicks at the jail. Mr. Hicks, by the grace of God, was medicated and retained and restored to competency, but not until after he spent, I think, close to 200 some days in jail, Your Honor, waiting.
184 is what I have.
Yeah. Mr. Hicks, Your Honor, took this plea, went home to a new baby that he had while he was incarcerated, which is incidentally gorgeous. I've seen her. And Mr. Hicks lives in Toledo. Mr. Hicks, unlike some of my clients, Your Honor, actually called when this was coming up. Mr. Hicks is doing so well, Your Honor. I understand the recommendation is probation, and that's more than appropriate. But I think it should be a very short probation, because when you look at the case, Your Honor, there isn't, Mr. Hicks has already served most of the time on both these.
I'm gonna give him 12 months.
And Mr. Hicks,
Yes.
is there anything you'd like to say to the judge?
Mr. Hicks, do you have anything you want to say to me?
I want to say thank you for giving me another chance to be with my family and get myself together.
All right, thank you. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. Court does recognize that at some point, Mr. Hicks was struggling with competency. He is now competent. He is following through on the things he needs to do to maintain that. and not have this happen again. It's sent to the court that you'll be placed on probation for a period of 12 months. During that term of probation, Mr. Hicks, you're not to violate any criminal laws. You are living out of state, is that correct?
Yes, ma'am, in Toledo, Ohio.
Okay, so not that far, kind of a suburb of us, but, so you're gonna have to come in person and meet with Mr. Moore to prepare the paperwork to transfer your probation. During your term of probation, you're not to use any alcohol or any illegal controlled substances. You're gonna be required to test as required, complete any assessments as required, and follow any other provisions of your articles of probation. Understand you're not to engage in any assaultive behavior. They have the right to search your house if they have reasonable cause to believe that you have items which violate the conditions of your probation. So are you currently licensed, Mr. Hicks?
No, ma'am.
Okay, so understand you cannot drive an automobile. Do you understand? Until you either get a valid driver's license and then permission from Mr. Moore. Do you understand that?
Yes.
Okay, there is credit for 184 days already served in the Lenawee County Jail, a crime victim assessment fee in the amount of $130. Are you employed right now?
No, ma'am.
I'm
But I
gonna
can,
order, okay,
I can-
I'm
I
only
can
gonna
pay that.
order. Okay, I'm gonna reduce your state or court cost to $350 from $750. The $30 supervision fee, $60 of tether, $350 in court costs, DNA fee of $60. There's $68 in state costs, and I already said the $130 crime victim rights fee. All right, and then
Restitution.
yep, I'm getting to that one. So on the unlawful driving away of an automobile, the attempted, again, the probation for 12 months, credit for 184 days already served. There is $675 in restitution that has to be paid. So understand that gets paid first, and then there's $68 in state costs. Mr. Moore, if he pays restitution in full, I'll waive the court costs, all right?
Okay.
Because I suspect he may be applying for SSI, and then there's $68 in state costs. So, Mr. Hicks, the address, let's see here, trying to get. Mr. Hicks, the address I have for you, and I don't want you to put your address on the record, but are you still on Booth Avenue?
No, I gave the new address to the,
Hold on. So, Mr. Moore, could you get his updated address to Miss Adams for me?
Yeah, I'm gonna,
I'll put you guys in a breakout room real quick after we're done, and Mr. Moore is gonna get your updated address, Mr. Shelton.
Okay.
We're gonna mail to you an envelope, and in that envelope will be 3 copies of your notice of right to appellate review, along with a self-addressed stamped envelope to me. So the first copy will be marked where they want you to initial it and date for each file. Okay, so there'll be 2 that you have to initial and date, fold them up, put them back in the self-addressed envelope, and put it in the mailbox to come back to me. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address on the form within 42 days. Do you understand that, Mr. Hicks?
yes.
If you don't want to mail them back, you could always bring them to Mr. Moore. But Mr. Moore is going to give you instructions to report to see him next Tuesday, and you guys can start the process of transferring out. It's $100 to transfer probation. Is that correct, Mr. Moore?
It's 200, but if we have an issue, we can request to waive it.
Okay, so you'll talk to Mr. Moore Tuesday morning. I'm going to give you a breakout room with Mr. Moore so you can chat real quick with him, all right?
Okay.
And he'll get that address, and then we'll mail that out to you. All right.
Good luck, Mr. Hicks.
Go ahead and join that breakout room, and when you're done, you can just hang up. All right, so we are back on the record now with Mr. Hill. So let me get Mr. Hill's file. Record should also reflect, I received back signed copy of the notice of right to appellate review from Mr. Mauer. Here's Mr. Hill's file.
I have Mr. Madrid.
I don't even know when we're gonna get there. What do you got going on downstairs?
I finished it all up.
Want to bring him down?
It should only take a few minutes.
Yep. All right, here's my Hill file. All right, so this is in the matter of the people of the state of Michigan versus Rodney Lamont Hill, file number 24-21703FH. I have Alfred Brandt appearing on behalf of Mr. Hill, P38586. And then I have Douglas Hartung appearing on behalf of the people, 36616. This is again the time for a plea. You're lucky, Mr. Hill, that you're always very conscientious and you always show up and communicate. And you had logged in the morning and I saw you, but I was in another hearing. So you were just here the wrong time, but I knew you would be here. So we adjourned it to today. So it's my understanding at this time, there is a plea offer that's been made. Mr. Brandt, is your client going to avail himself of a plea offer?
Yes, Your Honor.
All right. And Mr. Hartung, what is the plea offer?
I was going to plead to count one, Your Honor. The supplement, the narcotic supplement attached to count one will be dismissed at sentencing. Count two will be dismissed at sentencing along with the habitual supplement. The initial jail, the initial incarceration period will be set at 1 year in Lenawee County Jail, and there'll be probation thereafter.
Is there any agreement on the term of probation?
It's up to you, Your Honor.
Okay. All right. So Mr. Moore, this is Rodney Hill. The plea offer is he's going to be pleading to count one with no drug supplement. Count two and count three count two would be dismissed. And then the habitual offender supplement would be dismissed. And the agreement is he will serve 12 months in Lenawee County Jail. And wasn't he working that out with this employer or something? So was there anything about that we talked about?
Yep.
Hold on, Mr. Hill. Okay. So no other part of the agreement then? Okay.
No, Your Honor.
Okay, and then he'll have a term of probation after that, Mr. Moore. All right, Mr. Hill, we'll get to talk about that at sentencing or after we take the plea. All right, so Mr. Hill, you want to raise your right hand?
I kind of wanted to speak to my lawyer first.
Okay, so I'm gonna.
I just need like a one, like
no,
1
no,
minute.
it's okay, it's okay, it's okay. So, Mr. Brandt and Mr. Hill, I'm gonna pop you in a waiting room. Mary, I'm telling you, Joanne's gone, my life falls apart. So let's go on Madrid.
You're
All right.
We're good.
All right, I don't even know where Madrid is. All right, Alejandro Madrid. Okay. This is in the matter of the people of the state of Michigan versus Alejandro Luis Madrid, file number 23-21441FH. This is the date and time set for a probation violation sentencing. Ms. Underwood, you received a copy of the probation violation report?
We did.
All right, Mr. Madrid, you had an opportunity to read and review the probation violation report. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you? Yeah, speak up for me.
Yes, ma'am.
Okay, very good. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
We do not.
All right. Before the court passes sentence, is there anything you want to say on behalf of Mr. Madrid?
Mr. Madrid, thanks to court and the recovery court team very much for the opportunity to go back into recovery court. We think that's an appropriate response to this matter, Your Honor. I think he got overwhelmed and scared, and that happened. So we understand the recommendation, and we truly hope it doesn't take very long to get Mr. Madrid a bed.
All right, Mr. Madrid, anything you want to say on your own behalf?
I just want to say that I am grateful
to be in this recovery court. Like I'm like, I kind of wanted it to like be like up on my game, to know that I'm gonna have these drug screens more and more help. Like I've been telling my friends, it feels like kind of like probation for dummies a little bit, and I'm excited for that.
Okay.
But, yeah.
Okay.
I just want to say thank you for the
You're welcome.
chance to be here.
So, Mr. Madrid, the recovery court program is amazing, and I don't take any credit for it because the people that are involved in the program, I have seen them change people's lives. So, but you have to remember, as part of this, you don't get to leave programs. I don't care what happens. You have to ask permission to leave. And we're very reasonable, but until you fix yourself, you can't be a good family member, right? And you're on that path. So it's sent to the court that your probation will be continued. You'll serve 45 days in Lenawee County Jail, credit for 9 days. And as soon as we can get a bed, we will release you to inpatient. You are to obey and comply with all the rules and regulations of inpatient treatment, and you're not to leave until you complete it or you're given approval by the probation department. All right, so you do have the right to appeal the sentence. My bailiff's going to hand down to you your notice of right to appellate review, initial and date, 1 copy from my records, the other copies are for you. And if you wish to appeal the sentence, you would fill out the information and mail it to the address listed on the form within 42 days.
Thank you, Your Honor.
Thank you.
I believe that's my.
Yes. Mr. Daggermar goes in. Would it be possible to do 1:30 or sometime this afternoon?
Sure. Yeah, whatever works for you. I'll just be on Zoom if that's okay.
1:30?
Sure.
Okay, thank you.
Okay.
All right, the record should reflect I received back paperwork from Mr. Madrid. Good luck to you.
Thank you.
I'll see you when you get out. All right. Okay, so in the matter of Mr. Hill, I don't know what I do with your stuff. Okay, so we're back on the record in the matter of Rodney Lamont Hill. So, Mr. Brandt, your client wanted to speak with you. Have you had ample time to speak with them?
Yes, Your Honor.
All right, how do you wish to proceed today, Mr. Brandt?
We will avail ourselves of the plea offered by the prosecuting attorney.
All right, so Mr. Hill, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, controlled substance, delivering manufacture of cocaine less than 50 grams? Now it carries a maximum penalty of up to 20 years and $25,000 fine, but you understand there is an agreement that you will serve 12 months in Lenawee County Jail and probation. So is it your intention to plead guilty to that count?
Hold on. Is it a possession or is it delivery? Because I thought I was charged with a possession with the intent.
So it's possession with intent. So the way the statute reads, it says controlled substance, delivering manufacture of cocaine less than 50 grams, but then the statute continues on that says did possess, it's a PWID, so possess with intent to deliver less than 50 grams.
Okay. Yes, ma'am.
Okay. And so it's your intention to plead guilty to that count, sir?
Yes, ma'am.
Are you satisfied with Mr. Brandt as your attorney and the advice that he has given you?
Yes, ma'am.
All right, there has been a sentencing agreement placed on the record, but neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed terms of probation or fines and costs with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Brandt?
That is correct, Your Honor.
And does that sound correct, Mr. Hill?
Yes, ma'am.
All right. So if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Hill?
Yes, ma'am.
Drop Mr. Moore. All right. Do you understand that if your plea is, that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Hill, do you have any questions about the rights that I have given to you?
No, ma'am.
All right. So, Mr. Hill, how do you wish to plead to the charge that on or about February 2nd of 2023 in the city of Adrian in the county of Lenawee that you did commit the offense, count 1, controlled substance, delivery manufacture of cocaine less than 50 grams, and that you did possess with intent to deliver less than 50 grams of a mixture containing the controlled substance cocaine? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to get you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Brandt?
None, Your Honor.
Other than the agreement that was placed on the record, Mr. Hill, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right. So, Mr. Hill, on February 2nd of 2023, were you in the city of Adrian in the county of Lenawee?
Hold on. You said February?
February 2nd of 2023.
No, I think that date is kind of wrong. I think that's supposed to have been like in August.
Let me look. Hold on. Mr. Hartung, I'm looking.
I'm looking
back
to, hold on. He's correct. It should be, Mr. Hill is correct. It should be August 2nd.
All right, I'm sorry, Mr. Hill. So on August 2nd, and can you get us an amended information, Mr. Hartung?
We will do that.
All right, so on August 2nd of 2023, Mr. Hill, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
All right, and at that time, did you have in your possession less than 50 grams of cocaine?
Yes, ma'am.
And you knew it was cocaine?
Yes, ma'am.
You had no legal right to possess cocaine, correct?
No, ma'am.
All right, and when you possessed that, was your intention to deliver it, to give it away, or to sell it?
Yes, ma'am.
Okay, are you satisfied, Mr. Hartung?
I am, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
Mr. Brandt?
The court has, Your Honor.
All right, I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Ms. Adams, what date can I use for sentencing?
But we are using April 11th at 8:15.
All right, so Mr. Brand, are you available April 11th at 8:15? Now, Mr.
So if I
Brand,
could just briefly
I was going to
address
tell
that
you
date.
that obviously Mr. Hill has to be in person,
Yep.
but if you two decide that you can zoom in, that's between the two of you.
Yes, Your Honor. My client has asked the court, with all the courtesy the court has given him, he is finishing up a project for his employer that will take about 60 days. I've explained to Mr. Hill that he can't
Mr.
be
Hartung,
asking-
any objection to a sentencing date 60 days out?
No objection.
Okay, so Ms. Adams, could I get a date about 70 days out so you can finish up the job and
May 2nd at 8:15.
May 2nd at 8:15? Mr. Hartung, are you available?
I am available.
All right, Mr. Brandt?
I am available as well.
All right, so Mr. Hill, I will require you to come in person that day. You and your attorney can discuss whether he needs to come in person or not. Going forward, Mr. Hill, I'm gonna need you to come in and meet with the probation department. I'm gonna put you in a breakout room with Mr. Moore and he's gonna get some information from you. When you meet with them, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide that to your attorney and to the prosecutor's office. And they'll review that with you before the date of sentencing. Anything else, Mr. Hartinger, Mr. Brandt?
No, Your Honor, thank you.
No, Your
All
Honor,
right.
thank you.
I did, Your Honor, I did miss the plea agreement.
He pled to count 1 with no drug sup, count 2, and the habitual offender notice is dismissed. There is a Killebrew agreement to 12 months in jail and probation. And then sentencing is May 2nd at 8:15. Mr. Brandt, do you want to join the breakout room with Mr. Moore and your client?
No, Your Honor, that's fine.
All right, so Mr. Hill, I'm gonna open up a breakout room with you and Mr. Moore. I don't know if Mr. Moore will be your probation officer, but he's handling my sentencings today. Once you're done talking to Mr. Moore, you can just disconnect and go back to work, all right?
Okay, thank you, ma'am.
Thank you. Thank you, Mr. Hartung, Mr. Brandt.
Thank you.
Thank you, Your
Have a
Honor.
good weekend.
All right. Okay. All right, so now I'm going to go off live feed to handle a juvenile matter. Mr.